Section 44, decree of judicial separation not to bar subsequent proceedings for dissolution of marriage. Decree of judicial separation not to bar subsequent proceedings for dissolution of marriage. 1. A decree of judicial separation shall not prevent the institution by either party to the marriage of proceedings for a decree of dissolution of marriage. So even if there is a decree for judicial separation, while that
you can still be pushing your divorce,
you can file a suit for
dissolution of marriage.
So I think if you even have a situation where there is a threat of grievous bodily harm, attempted murder, and that is to be your ground for dissolution of marriage, you can quickly initiate an action for separation.
Separation first.
Then or you can be a preliminary prayer for separation pending the substantive suit for the dissolution of the marriage. So that can be a preliminary or probably an interlocutory order. Then subsection 2 of section 44, subject to the next succeeding section, the court may in any proceeding for a decree of dissolution of marriage on the same or substantially the same facts as those on which a decree of judicial separation has been made, treat the decree of judicial separation as sufficient proof of the facts constituting the ground on which the decree was made. Subject to the next subsection, the court in any proceedings for decree of dissolution of marriage on the same or substantially the same facts as those on which a decree of judicial separation has been made, treat the decree of judicial separation as sufficient proof of the facts constituting the ground on which that decree was made. Who gets that point? Who gets the point? He says that if the court has given a decree for judicial separation, says the court can rely on that granting of that decree so far as the facts that they are using to apply for dissolution of marriage are the same with the facts that were used to grant judicial separation. The court can deem that granting of the judicial separation as sufficient grounds to grant. So somebody can just bring the order for a decree for judicial separation and say, based on this decree and based on the same grounds in that decree, I'm praying this court to dissolve this marriage, and the court will deem same as substantive enough to grant the dissolution. Is that okay? Yeah. Then subsection 3, because it says it's subject to this next section. So the court shall not grant the decree of dissolution of marriage without receiving evidence by the petitioner in support of the petition. The court shall not grant a decree of dissolution of marriage without receiving evidence by the petitioner in support of the petition. So even if you are relying on
judicial
separation,
you
must give evidence. You must give evidence. So maybe the evidence now will be the person tendering the order of judicial separation, the decree of judicial separation, and also reiterating the same facts that were reiterated to get the judicial separation for the purpose of getting the dissolution of the marriage. But there must be evidence. So you cannot, that is why I think this the parties have agreed in terms of settlement does not necessarily work in dissolution of marriage. There must be evidence. They must enter the witness box and give evidence in dissolution of marriage. Marriage to be dissolved.